advised, the Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CA CR 23-0370, State versus Robert J. Foster. As a reminder, this hearing is being video and audio recorded. In a few days, the video will be uploaded to our YouTube account. So, counsel, before you begin your argument, please identify yourself and the party you represent. Each side will have 20 minutes. If the appellant's counsel would like to reserve time for rebuttal, you're free to do that, but you are responsible for keeping track of your own time. We have read the briefs and conferenced the case, so we are familiar with the issues. It's not necessary to repeat what's in your briefing. With that, counsel.
Thank you. Good morning. I'm Louis Fidel, and I represent Rob Foster. The central issue in our appeal is the refusal and failure to give a knowledge of involvement instruction as an element of the offense in the case. The state has acknowledged in its answering brief that that is an element of the offense. And that's, of course, in contrast to what happened at the trial court below, where the state argued successfully, in the sense that they persuaded the trial court, that it was not an element of the offense and that no such instruction should have been given. The result is that there was no instruction given on that element, and the jury was not in a position to make a determination on an essential element of the case. That is fundamental error. It goes directly to the heart of the offense of conviction. But
counsel, there's no dispute that Mr. Foster knew what his own conduct was. He knew what he did. He knew that he gave a thumbs up or exchanged some kind of hand gestures with the driver of the BMW. He knew that he floored it. He knew the manner in which he drove. He knew there was an accident. So he had knowledge of the underlying facts. It seems to me what you're saying is he didn't know that his conduct would be considered a statutory violation, which is essentially a mistake of law defense. Is that an accurate summary?
In part, yes. He had knowledge of those specific acts that you mentioned. He knew that he had engaged in that conduct, but he did not know that he had been involved or was involved in the accident. What he saw from a position of hundreds, if not more feet away, was an accident that occurred in front of him that involved the other vehicle, Carrasco, the driver, and the victim. From his view, those people were involved in the accident, and he did not know that he was involved.
He did not know as a legal matter that his conduct would be considered a violation of statute.
Well, he did not know that he was considered to be involved in that accident, thus necessitating an obligation to remain at the scene under the law.
So there's no fact that he was unaware of. The only dispute is whether he was aware that his conduct came within the scope of this particular statute.
Well, unless you consider being involved in the accident a fact. I think I understand the question. I don't believe he understood, or in fact I know he did not believe that he was involved in the accident. Now that I think is a legal conclusion, and it's something that the jury
and the statute doesn't just say he knows that he was involved in an accident. It says he was driving a vehicle involved in the accident.
Right.
And so I guess your view then on which vehicles are involved in an accident. Is it only vehicles that strike each other? Could another vehicle be involved in the accident?
Well, I think it could be. Under the cases, you can find that a vehicle that is not physically involved in the accident is nevertheless involved, necessitating an obligation to stay at the scene. But again, that's an issue for a jury to decide. But the statute also requires, in our view, that the driver have knowledge. They must know or have facts that they should have known that they were involved. It's a two-part requirement. There's involvement and knowledge of involvement, just like under the Porras case, while the statute does not say that you must have knowledge of injury, it just says injury, there is nevertheless a knowledge of injury requirement.
What, in your view, what instruction should have been given?
Well, the instruction should have included that an element of the offense is that the defendant must know or should have known that they were involved.
And I probably should know this, but what instruction was requested by the defense? I know there was a withdrawal instruction that was requested. Was there a separate involvement instruction that was requested?
I believe there was, yes. It was... Yes, it was proposed instruction number 8, and it was, we called it leaving the scene of an injury or fatal accident, and we included as the first element was that the state must prove that the defendant was driving a vehicle involved in an accident resulting in injury or death. 2, the defendant knew that his vehicle had been involved in an accident. And 3, knew that the accident resulted in injury or death of another person.
So that was not denied. It's the second part that you're saying should have been given.
Correct. Correct. That is the part that should have been given. There was an instruction on knowledge of involvement consistent with Porras and Blevins. I'm sorry, knowledge of injury. So in our view, that is really the principal issue. Now, the state has argued in its appellate brief that element was implicit in the instruction, but frankly, I think that argument fails for a number of reasons. One, it's illogical. The notion of an implicit instruction, frankly, doesn't comport with what's required. There may be, as the Porras case tells us, there may be elements that can be implicit in a statute, but the whole purpose of instructions is to make explicit for the jurors what it is that they have to analyze and what the law is that they have to apply. If jurors don't receive explicit instructions on what the elements are, there's a host of problems that arise, one of which is we don't know if the jurors understood that to be an element. And we don't know if all the jurors understood.
And are you saying you need to tell the jurors that he has to have knowledge? I mean, the part of it that seems helpful, you have to have actively participated in the immediate chain of events culminating in a collision. What's wrong with that language?
Are you referring to the language from the court's involvement instruction?
Right, the involvement in collision instruction.
Well, because it doesn't address that issue of knowledge. It talks, that in a sense addresses the issue of whether the jury believes the driver or the vehicle was in fact involved, but it makes no mention of whether the driver had knowledge that they were involved. And in many cases, in most cases probably involving an accident where there's just two cars, it probably doesn't come up because a person hits another car, they know they hit another car, and so there's not really a question about knowledge. But when you've got a scenario like this case where there are two cars that were physically involved in the accident and one that indisputably was not, that becomes more of a concern. Did the driver of that third vehicle, in this case Mr. Foster, did he know that he was involved in the accident? Especially where, as here, the facts are that he was quite a distance away and did not arrive at the scene.
What are you saying is quite a distance away? How far behind?
Well, there was uncontroverted expert testimony from an engineer who we called, who determined that the closest Mr. Foster could have been was hundreds of feet from the collision at the time it happened.
300 to 400,
Right.
going over 100 miles an hour, approaching an intersection. What's the stopping distance at 300 to 400? I mean, that's a calculation that can be made. We're talking a matter of a second or two behind. He's not 3 minutes behind. A few moments behind at best, when he had just been, as he acknowledged, racing with the individual, giving a thumbs up, had sped up himself from a dead stop to over 100 miles an hour, and then managed to slow down enough within that 300 to 400 feet to make a turn after watching a car accident. No possibility that the jury could have said he knew he was involved?
Well, they could have, but they should have had the ability to make that determination. And that's the problem, is that the way they were instructed, they were not told, you must decide. This is an element that you must decide. And if you're not persuaded beyond a reasonable doubt, then it's not guilty. But they should have been able to make that decision. And the facts are, as Your Honor pointed out, he was, by the expert's estimate, 300 to 400 feet away. We had a witness, Ms. Hoflick, who was very close to the intersection. She heard the explosion, what she described as sounding like an explosion. She said it was 10 to 15 seconds before she saw the Lamborghini make the turn. So it is a number of seconds, but it is hundreds of feet. And I would submit that the hundreds of feet is the operative principle, because that's the distance from the collision that it occurred. But at the fundamental level, it's a jury question. And if the jury had believed that, based on all of those facts, Mr. Foster knew or should have known that he was involved in the collision, well, they would have made that decision. But in this case, they had no ability to make that decision.
Isn't this case very similar to Korovkin, in which case doesn't Korovkin establish that under these facts, yes, he is involved?
Well, it's similar in some ways, but it's different in critical ways. And the principal way in which it's different is that Korovkin did not address this knowledge of involvement element. Another principal factual dispute.
Did they request an instruction in Korovkin regarding knowledge?
I don't believe they did, no. But a principal factual distinction is that there you had two people who were, head to head, basically, and one of them avoided the victim vehicle and the other did not. That's not the case here. We have, in this case, as we covered, somebody who is 300 to 400, hundreds of feet away when it happened. That's a big difference. That's a big difference in the case. And Korovkin, as I say, never addressed that knowledge element. It was talking about strictly whether someone who is not physically involved can be nevertheless involved. And that brings up a compounding issue, which is that the instruction that was essentially a quote, it's a paraphrase, but a very close quotation from Korovkin, really compounded the problem of failing to give the knowledge of involvement instruction, because that, in our view, constituted a comment on the evidence. It was essentially, the way that was worded, it was taking specific language from the court's analysis of the facts in Korovkin, and it turned that into an instruction to the jury that amounted to a directed verdict, that somebody, by any measure, is involved in the collision.
If they had stopped before the by any measure language, would that have been okay? Just a driver who races another driver may be found to have actively participated in the immediate chain of events culminating in the collision, period.
Well, no, because There are two problems. One, it doesn't mention knowledge. And two...
And you agree, you're saying it's knew or should have known?
Yes, yes. The second problem is that it doesn't really give any guidance. I mean, if I tell you a person who races another driver may be found to have actively participated, the next question is how, why, when? Like, an instruction must give some guidance. If it doesn't give any guidance, then it's really not an instruction. It's just a comment. And so that's a deficiency in that instruction.
But your proposed instruction didn't really do more other than it just kind of used the language of the statute and said that you knew or should have known?
Right. And then, you know, as the court knows, we objected strenuously to this, what we think of as the Korovkin instruction, which is entitled Involvement in the Collision. We think that was an inappropriate comment on the evidence that involvement.
So how are you saying we explain involvement? I don't understand that. You're
Well,
just saying use the word involve and let the jury sort it out?
Yes, that was our strategic analysis of it, was that involvement is a term that's commonly used. People know what it means, and it's not a term that requires definition. The jury can use its common sense. It can review the facts, and it can determine if someone was involved. But to give an instruction that says may be involved and then continue to say by any measure may by any measure have been a participant and implicated, and it specifically references for the purposes of leaving the scene of an accident, and then without regard or condition upon the actual physical contact.
So you don't think the court should have even said a person who races another driver who collides with a third car should have even been explained to the jury? You're going to let them decide that
Yes.
issue as well?
Yes. Yes.
But aren't they being left to that by saying they may be found? We're not saying you have to find that they're
Well, no,
involved.
I'm sorry if I could. My clarification was, you're saying that sentence shouldn't have been given either.
The first
Right.
sentence. I don't think it was necessary, and we don't
That's what I
think-
thought I understood.
Yes. And to respond to, well, if you wanted to finish the question.
I'm
No,
sorry.
I'm just assuming that your point would be may be found is not directing that, or maybe not what you would be saying, but that's not directing the jurors that they have to find it based solely on the fact that they're racing another driver. It just says may be found. So we're leaving that to the jury to decide.
Yes, and the problem here is that the maybe, the permissiveness of the maybe, is then undercut by the rest of the statute, or the rest of the instruction, where it says by any measure and without regard. I mean, those are really, really problematic because without regard to the actual physical those are important details that the jury must analyze. They must analyze all of the facts.
Telling the jury without regard to whether there's actual physical contact, that's simply informing them that physical contact is not required to establish involvement in the accident. What's wrong with that?
Because it's part of the facts that the jury heard and should analyze. The jury is supposed to analyze based on the totality of the circumstances.
But they don't have to analyze whether the car hit the other car. That's everybody agrees the car did not hit.
There's no question about that.
So this instruction is just saying the fact that you didn't actually hit the car doesn't preclude a finding that you were involved in the accident.
But it's also saying by any measure, and the by any measure is also problematic because all of those measures, all of the details are critical to the analysis, and those are core problems with this instruction in the case.
Counsel, you have two minutes left.
I have 2 minutes. I'd like to reserve the rest of my time. Thank you.
Thank you.
May it please the court, Eric Knobloch for the Arizona Attorney General's Office representing the state of Arizona. The court here did not abuse its discretion because the instructions properly set forth the law and gave the jury the legal principles necessary to apply the facts and make a judgment. Moreover, causation is no longer an issue in front of this court. The jury specifically acquitted him of second-degree murder and of aggravated assault, and specifically found that there was no causation in regards to count 3. And this is important because the legislature has expressly delineated that in this statute, leaving the scene conviction is a Class 2 felony if Foster had caused the collision. However, it is a Class 3 felony if Foster did not cause the collision.
But you don't think there's a requirement that the defendant would have to know or should have known that their vehicle was involved in the collision?
So, turning to issue 1, the state does concede that there is a knowledge, a scienter component on the involvement.
So it was error not to give the requested instruction? Was there a problem with the requested instruction that the defendant sought?
The problem is that it's not expressed. No court has found that there is that expressed requirement.
But you're agreeing that there is a requirement?
There is a requirement, but we feel that is implicit in the involvement.
But so what was the problem with the instruction that was requested?
So there was no problem with the involvement or the question or the instruction requested, and the state actually argued that in its closing arguments. It argued the knowledge component, and so the state's specific arguments that imparted that understanding to the jury, and to go back, the state had made its argument behind closed doors outside of the jury's presence that there was no knowledge component. The state now concedes that yes, there is a knowledge component implicit in this. But the jury.
I'm understanding your briefing to say that the knowledge component was met by his statement that he felt morally responsible. Is that what you're?
So the evidence that supported that was that he admitted that the witnesses described Foster and the BMW racing at extreme speeds. That on that second race, the BMW and the Lamborghini were going faster. They were more engaged, and they were driving longer. And the witnesses described the explosion or the collision as an explosion. And then Foster's testimony itself showed this knowledge component because he admitted that he had multiple times accelerated hard and got on the BMW. With that last race, he floored the car for 5 to 6 seconds.
But was his car? But the statute says he was driving a vehicle involved in an accident.
Correct.
So his vehicle was involved in that accident, even though it didn't strike it, and he wasn't close enough to push the vehicle. Not
physically, and the legislature did not explicitly include that physical language in the statute, and I think that's important.
A vehicle involved in an accident, so they don't have to be anywhere near?
Depending on the circumstances, yes.
Yeah, but I was reading your brief as saying he said he had a moral obligation to stop, and it seems like everyone in the universe has an obligation to stop if there's an injury. Hopefully we all have a moral obligation to do that, but how does that show a knowledge that he was in a vehicle that was involved in an accident?
And I think it's important to note that the state is arguing while there's a knowledge component implicit in that, it is an objective standard. It is know or should have.
Right, but that's what the requested instruction was.
That was what the requested instruction was. Down below, the state argued that there is no knowledge component.
But so you're conceding that it was error not to give the instruction, and you're just saying it was harmless?
We are not conceding that it was error. We are stating that while there is a knowledge component, it was covered by the other instruction, and no separate instruction was necessary because it was included in that involved.
Where was the knowledge?
It is included in that involved in the collision.
But the question is, do you know that you're involved? You would acknowledge that if he's 5 minutes behind, it's pretty hard to argue that you know you're involved, even though you're racing, and the racing is what ultimately caused the accident. So you're sort of involved in the accident in some way, but would you say that you're involved such that you satisfy the elements of the statute that said you're in a vehicle that's involved in an accident?
Yes.
So even 5 minutes?
Yes. And the reason is because racing in a vehicle is an inherently dangerous activity. in which it is foreseeable that something like this could happen. And when you set into course those events,
But so that applies, this is a 100-mile race. We're going across 2 states. We started that. I'm 50 miles behind. The other person strikes a pedestrian and kills them. I'm not even at the scene of the accident. I turn off 5 miles before. I've left the scene of an accident.
so, and I think that's where the separate instruction on involvement, where it described the certain legal guideposts that the jury must look at to determine whether or not he had been involved,
And
outside of the knowing component.
What do you make of the language, by any measure may have been a participant? By any measure, I started this race 100 miles ago, but 50 miles later, I've turned off. But by any measure, I'm involved in an accident such that I can't leave, where I never even arrived at the scene of the accident?
So the way the state views this instruction is that it is broken down into 3 components. The first component is the jury must decide whether or not the Lamborghini was racing. Vehicle A was racing the BMW, vehicle B. And then it goes, may be found to have, and then this is the second part, have actively participated in the immediate chain of events culminating the collision. So there the jury must find that the collision was a result, was that final set of that chain of events that was put into course by the racing. And so that's where, if the vehicle B, if the BMW had turned off into a parking lot and then got into an accident, well, that's no longer part of that chain of events. That's no longer something that Foster had set into course by racing. Here, there's no question. At 3 seconds before the accident, the BMW was traveling at 140 miles per hour.
But there's no question that his vehicle, as opposed to just him, hypothetical for you that doesn't involve me in a car, but I start a street racing event, and I just wave the flags to start people off. 100 yards down the road, there's a fatal accident. If I leave, am I guilty of leaving the scene of a fatal accident when I was the flagman that started the race?
If the jury determines that that was part of the chain of events, the ultimate collision, if that was the culmination of the part of the chain of events, yes.
But that seems like causing the accident, as opposed to the statute that says driving a vehicle involved in an accident. I'm trying to understand how a vehicle involved in the accident seems different than just, were you part of the causation chain?
Correct. And it's a difficult question, and the state actually did a very good job in closing, and I would direct the court's attention to a portion of the closing arguments in the state. It's on the May 9th transcript on page 79. And the state discusses this involvement and the difference between causation, and says involvement is very similar to causation, and they are rooted in each other. But involvement is when a person is racing another vehicle and the other vehicle is involved in a crash that results from the natural flow of events of his conduct. Here, he was racing, and the racing caused the crash. And so he set into the action the events that led.
But he's acquitted of that. He's acquitted of causation.
He's acquitted of causation, yes. And
So
so when
you're
I say
saying they're closely related, so it seems odd to nevertheless be convicted of leaving the scene of an accident that you didn't cause.
correct, but it's the involvement. And so the state is highlighting the difference between involvement and cause. In involvement, you set off that course of events. You didn't necessarily cause that crash, but you set off the course of events that ended up resulting in that injury.
I'm not understanding how involvement means setting off the course of events, when involved for purposes of leaving the scene is just you're driving a vehicle that's involved in an accident. It seems different than starting the chain of events that results. That seems like a causation argument rather than I was just involved in an accident.
Well, I think it's different. So the causation argument is that Foster racing the BMW caused the BMW to go to that speed. That's where that causation is.
Okay, but
then it's a separate step for that BMW going that speed caused the crash. And so there's those two causations, but it's not a direct causation of Foster Racing caused the crash. It's that Foster racing the BMW and the BMW getting into the crash, that was the involvement. And so Foster's action of racing the vehicle is so inherently dangerous that it's foreseeable that racing could result in a crash. And
Can I just jump? It's not that he caused the racing either. He was involved in racing.
correct.
So it doesn't matter who started it. Both were playing. And I just want to make clear then, the legislature decided there's a difference. There's a causation piece if you cause the accident, and there's an involvement piece. So we have to distinguish between the two.
Correct.
So your point is that if I'm involved in the racing, and the jury then can decide that I have enough information to know that that meant my vehicle was involved in the accident, because we were racing, I gunned it, went to the floor, over 100 miles an hour, stopped or slowed down just moments before the accident happened, was aware of it, and even that moral knowledge doesn't necessarily prove it, but the jury could draw from that he was aware of his involvement. Isn't that the point that the state's making?
Yes, and that is why it's an objective knowledge component and not just a affirmative knowledge component, because
he could say, I didn't even have any idea.
Correct.
But the jury could still find, no, under the facts
where-
of this case, he had to have been aware.
Where was the jury told, though, that he has to know or should have known?
So, and that's in the arguments. The state, the defense, both did a good job of imparting that knowledge onto the jury.
But then the instructions they're given doesn't make any reference to know or should have known.
No,
and it just says, by any measure, you're involved. That seems problematic.
Well, and the state does, again, concede that there is a knowledge component in here, but no court has expressly found.
But if it's there,
and-
you're conceding that the instruction that was requested should have been given.
Yes.
Okay.
Was it harmless error then?
Well,
not
no,
to-
sorry. Let me take that back. We concede that there is a knowledge component, but it did not need to be given because it was implicit in that involvement.
Was it harmless error to not give it because of the way the state made the arguments? I mean, is that what saves it?
I think the court can look, if it is confusing, the court can look at the arguments from the state and the defense to see if that legal underpinning was nevertheless imparted on the juries. And yes, I do believe that here.
So you say knowledge is required. Knowledge of what exactly?
Knowledge of, and again, it's an objective standard, knowledge that he knew or should have known that he was involved in the collision.
Right.
But it
There's no
says the
dispute-
vehicle. Sorry. Go ahead.
There's no dispute that Mr. Foster knew what he did and that he knew that an accident occurred.
Correct.
What other knowledge is required?
There's also, and this is porous, where they expressly found that there is a knowledge requirement of injuries. And importantly, they did say that that was an objective standard because a driver can't just leave the scene saying, well, I didn't know that there was injuries. You have a duty when there's, based on the surrounding circumstances, if there's a crash, you have a duty to stop, identify yourself, and make sure. And I think that's important in this statute specifically because this statute is not only guarding against criminal responsibility, it's also guarding against civil responsibility. And so the legislature has made it clear they want drivers to stop and identify themselves, give their information, whether or not they have they're facing criminal responsibility.
Was Mr. Foster required to know that his actions would be deemed involvement in an accident?
Yes.
Could I ask another question just about the flight instruction?
Sure.
I understand the flight instruction relating to the homicide charges. It doesn't make a lot of sense to me to instruct jurors that if you leave the scene, you're guilty of leaving the scene.
So first I would say that the state have a duty to prove every element of all the charges at the trial. And so that would go to second-degree murder, that would go to aggravated assault. But I also note that the instruction specifically points not to the elements of that they would satisfy the elements of leaving the scene. And in fact, the instruction says that you can't use this as guilt, but it also says that this goes towards consciousness of guilt specifically. And so that's where it's a difference. It's not looking towards, oh, does he satisfy the elements of leaving the scene?
But that, it goes to consciousness of knowing that your vehicle was involved in an accident, you've left, and that goes to knowing.
Well, in the court, the jury could very well use that for consciousness of guilt of whether he knew that he was leaving the scene. The fact that he left, didn't contact authorities for 2 weeks, and that when detectives on their own contacted him, he was nervous because he knew why they were contacting him. Yes, I do believe that can go to evidence of whether or not he knew that he was involved in the collision.
That he was in a vehicle that was involved in a collision. And even though his car didn't hit another car, his car didn't force the other car off, that he would. Correct. He would know that.
What was the evidence that supported the flight instruction?
So the evidence that supported the flight instruction was that he made a fearful split-second decision after he saw, in his words, the explosion, to turn before he had maintained that he was going to continue going straight. And he made that split-second decision to turn off before the collision and to avoid the collision. And then he drove home.
That sounds like you're not involved in the collision, if you can avoid the collision by turning off.
But isn't that a jury question?
Again, yes. And again, you're looking at whether or not it's physically involved. Here, he, as the state maintains, he engaged, he was part of the course of events that led up to that collision. And so then the other evidence that supports that is that he went home and he did not contact police for 2 weeks. And then specifically when he was approached by detectives, he was nervous because he knew why they were approaching him. And then very quickly on the withdrawal from racing instruction, the two proposed withdrawals instructions would have only served to confuse the jury. Both of those instructions pointed to the state's, I think, was criminal responsibility, and the defense was the state's was causation, and the defense was looking at the criminal responsibility, and those both go towards causation. And so that's why it wasn't error to give that, because it would have only confused the jury. And then for the same reason, it's harmless because it only goes towards
causation and involvement are linked.
So they're not linked.
But there's a bit of an overlap.
So as the state said in its closing, it's very similar, but it's different. And it has to be different because the legislature itself has delineated that you can be convicted of involvement, but also not cause. And so here, and the reason is because this statute goes not only towards criminal responsibility, it goes towards civil.
What if you're, I'm not agreeing that the withdrawal instruction requested was, it didn't seem to have any parameters like how soon did you have to withdraw. But do you disagree with the general concept that if you withdrew with sufficient time to stop this chain of events, that you shouldn't be deemed to have been involved in the collision?
I would think that would be a jury question. Here, there was no question.
But why?
That he did not withdraw. Because I think...
Well, it seems like there is a question. If he avoids the collision by turning left and he's apparently driving slow enough to be able to turn left, why isn't that a jury question?
So I guess I'm misunderstanding your question.
Well, you're saying there's no question that he was involved, but it seems like if he's far enough behind that he can turn before he gets to the collision, it seems like it's a jury question whether he's in a car that was actually involved.
Because at that point, even if he was able to turn off, he had set in motion the course of events that led to that. And that's exactly what the instruction here informed the jury.
And don't we usually require more for them to withdraw? They got to let the other side know that they're doing it. Hitting your brakes in the middle of a race and within a few seconds causes an accident.
And
how do you withdraw from that under those circumstances versus maybe the car race that's going on for days?
Correct.
You say, look, I'm done. We're not doing this anymore.
And specifically because between 5 and 3 seconds, the BMW was still accelerating.
I know your time is up, but I do want to clarify something. Did I understand you a moment ago to say that the state had to prove that Mr. Foster knew that his actions would be deemed involvement in a collision?
That he knew that he was involved in a collision. Yeah, he knew or should have known.
Okay, there's no dispute he knew what his own actions were. There's no dispute he knew an accident resulted. Does the state also have to prove he knew that those actions would be deemed a violation of the statute?
No.
Just involvement in the accident.
Correct.
There's a difference between
Correct.
knowing
Yes,
it's a
to
violation
the legal, that
versus
it's
knowing.
illegal.
Okay.
Correct.
All right, thank you.
Thank you.
Counsel?
With the state's concession that knowledge of involvement is an element of the offense, it is clear that it was fundamental, reversible error not to instruct the jury on that element. That's what the Blevins case tells us. It was the year after Porras, the state or the court gave an instruction that simply mimicked the leaving the scene of an accident instruction, did not include knowledge of injury as an element that must be proven, and that was found to be fundamental.
Did the state concede a knowledge element in the closing argument? Did it say, you've got to find that he did it? What was the closing argument?
No, in fact, the closing argument is really problematic because while the state did talk about knowledge of involvement, the state objected when the defense brought up the issue of knowledge of involvement and said that misstates the law, and the objection was sustained.
And I assume the state objected to the requested instruction.
Yes, objected to the requested instruction, and that part of the transcript is on May 9th at page 91.
Is a failure to instruct on scienter always reversible error, even if the defendant admits that he had the requisite scienter?
Yes, it is, because it's a jury question. It's a jury question. The jury can take that into account. That's a piece of evidence that the jury can evaluate, but it must have that instruction. If it doesn't have the legal instruction on what the element is, even if both sides had been permitted, if the state had permitted the defense and the court had permitted the defense to argue knowledge of involvement, without the legal instruction that says this is an element that the state must prove, it's untethered. It's mere argument without legal support. Thank you.
Thank you. Thank you for your presentation. We will take this matter under advisement and issue our decision in due course. We're adjourned.